Hi, welcome to All Things ADR, the podcast. My name is Mwewa Stupida and I am the host. Today, I'm delighted to introduce to you our guest, Bob Mwewa. Bob is a practicing advocate of 12 years, having previously served as Deputy Chief State Advocate at the National Prosecution Authority. He holds a Master's of Law degree from the University of Limerick with a specialization in youth crime and several postgraduate diplomas in psychology, terrorism, and child justice. He's an Irish fellow and certified trainer in gender-based violence and child diversion. In terms of experience, it doesn't get bigger than this. He has litigated many high-profile cases and is on record in cases that set precedent in human trafficking, evidence production, case to answer, and self-defense, amongst others. He is currently the Deputy Executive Director at APP Zambia, a leading child justice organization. Hi, welcome home.
Hi, it's a pleasure to be here. I'm happy to be here to share and have this discussion.
Okay, today's topic is an interesting one. It centers around alternative dispute resolution, but with a focus on the criminal justice system. Most of the time when we speak of ADR, it's usually about commerce, industry, we tie it towards arbitration, mediation, construction, adjudication. But today we're looking at it from the angle of the criminal justice system. Does ADR have a place in the criminal justice system? Has it been used before in the criminal justice system? And like we said from the top, I think Bob is probably one of the best suited people to take us through this discussion. Now, when we also speak about ADR and the criminal justice system, what we have in mind is restorative justice, mediation, plea bargains. That's a circle of play we're in at the moment. So I'll hand over now to Bob. Maybe you can take us through these various topics and indeed whether ADR is in the criminal justice system.
Yeah, thanks. ADR in the criminal justice system is an interesting concept. I think one of the first interesting parts about it starts from the use of the term ADR, is alternative dispute resolution in criminal matters. I think over the last couple of years, before I really get into the bit of it, we have seen the term ADR in criminal matters being used a bit more frequently amongst, I think, professionals. And particularly, I think it started with the president. So I think from there, it's been part of our talk. Last year, it should be when during the opening of the criminal sessions, we were visited by the Ugandan Chief Justice, who used also the term alternative dispute resolution in criminal matters and gave a talk on that. This year again, during the opening of the criminal sessions, the agenda was yet again, it was called alternative dispute resolution in criminal matters.
Yeah.
So what we're referring to, I think, because most people, like you said, it's for use it in a commercial context. But the background we accept is that the crime, when it is committed, and when we go to the courts, that is also a dispute on its own. It's usually an allegation that someone is denying. So it's also a dispute that needs to be resolved. So what we are basically asking is there another way we could resolve this issue between these parties? And that's where we, I think, now have this term of alternative dispute resolution in the court. So the normal route, or the usual route, would be what is a trial, a criminal trial, where when someone is arraigned or charged or indicted before a court, they are taken before in court, they take plea, and the trial is supposed to take place, witnesses are called, and subsequently the person is either convicted or acquitted. So what would be the alternatives to this process? So I'll look at on two fronts.
Yeah.
There's the statutory ones, which are, I should say, already stated in our laws, and then there are others which we've been using as custom.
Yeah.
Yes, which I think I'll touch on later. So now I was having the newest one, which might be the shortest one, is in relation to children in conflict with the law. formerly known as juveniles.
Yeah.
Yes. So when the new Child Code Act came, it changed a lot of things in that landscape. And one of the main things that was there is under Section 58, where we find what is known as diversion. So diversion, in the context of children and the Child Code Act, is that when a child is suspected of having committed an offense or is arrested or apprehended for having for maybe suspicion of committing an offense, it says that the first port of call, the first thing that should be done to the child is to divert them. So to divert them is to take them away from the criminal justice system. So already that sets, it's a statutory provision that creates, should I say, ADR for children in the criminal justice system. So the main route would have been go to trial, but the law says no, let's use another route. So amongst these routes are what is known as cautions. So caution is basically a warning by the officer to who is arresting the child, and it can be formal, where it's written down, or it's informal, where they just tell the child, don't do this again, otherwise you find yourself in trouble. It can also be through mediation. I think you're more of an expert on that, but where parties actually sit down and I think discuss and hash out what the issues are and find some common ground. There's also other types such as family conferencing.
Yeah.
Because usually because there's a child involved, the law now wants to bring in the larger aspect of who are the guardians and the parents of the child, so that the well-being of the child is taken into account when this process is being done. And then the child is also supposed to go through what is known as diversion process or option, where they are supposed to take on activities that would make them reform from doing this again. So all in all, in this process, the child never touches court. The child never goes through court, no witnesses are called, and the dispute is resolved. So in practice, what usually happens is usually family conferencing and mediation, because most people, they do understand they shouldn't make mistakes, and it's easier to sit them down, especially with families, and sometimes you use senior members of the community, church leaders, and we usually find a way to have a common ground. And when this is met, restorative justice sometimes comes in, where if you have offenses like we have seen, which are like malicious damage, where some property has been damaged, that property is replaced. Yes, yeah, sometimes it's maybe an issue of insulting language, apologies are given, and the avenues go on and on. Yeah, so of course there are a few challenges there which have to do with the severity of the offenses, but maybe we can cover that one towards the end completely. Now for adults, and the most common one, which has been on our books for ages, it has to do with what is known as reconciliation.
Okay.
So reconciliation is found in the Criminal Procedure Code, should be Section 8. Yeah. So this one is related to misdemeanors. Personal misdemeanors, usually like assaults, thefts, except insulting language, and things of that nature, which now this one is usually promoted, or is supposed to be promoted by the courts. So we do have an instance where, unlike diversion, the accused person in this case will get to a court. So they will get to a court, and the courts will look at the charge in question, and then the courts will advise and say, well, could we maybe consider discussing this matter amongst yourselves and reconciling? This is a very, very common approach in our jurisdiction. Over the time of practice, this has been used countless times by people. Sometimes, and it's also got its own issues, it also comes up at police stations when the matter is reported. The officers there sometimes may encourage reconciliation, especially if the cases are are minor in nature, particularly if it's assaults and petty thefts and things like that. So you find that the end result, usually when you're dealing with reconciliation, is that when the parties go and discuss, they will come back to the courts and say, we have discussed and we have reconciled, we are now either forgiven this person entirely and I don't want to proceed with the matter. And the matter at that point is usually neutral. So there's no conviction, no appeal, no record of that, and the case ends there. Yeah, in the background, usually there's, to be honest, there's some restorative justice that usually happens. Like people are compensated for transportations, and maybe even if there were injuries that were occasioned, it could be hospital bills that are covered. And then I think the main, for criminal justice, I think one of the ideals is to hold society together. And if these situations happen, I found cases, not to digress, but I found cases where I remember one year, there were several simple assaults, and all of these assaults, they happened at a party. It was a community party, and there was a disagreement about food, and people ended up being a bit rough with each other. Yeah. But in the end, they were all neighbors. And if the criminal justice maybe had proceeded in the strict sense, we would have had maybe a street where there's a family member locked up at every other house. Now, what would have been the cohesion like in that community? So now you see why the principle of reconciliation there would be a better way to go about it. Because if they invited each other to the party, they mean they're friends.
Yeah.
So that's a disagreement.
So would you be saying that with this option, at least at the end of the entire process, the affected parties have a blank slate?
Yes, this is completely a blank slate. It's like the case really never happened. There might still be a report at the police station, but in the courts, the case is withdrawn and it's done.
Yeah, and then I'll just take you back a bit in terms of the same question. When you're dealing with children as well, two things here. Does that whole process as well allow the child to then have a blank slate, which I think is important for a young person growing up, going forward? But also just confirm for us, because I know in the past we had various statutes that gave different ages for who a child is. So what's our current age when you look at the Child Code Act, the Constitution? What's the current defined age of a child? And, does it also give them a blank slate once they go through the diversion or family reconciliation processes?
Yes, okay. Yeah, that's we do even now have different statutes that relates to what the child is. You find that in certain provisions of the law, a child, for example, in the Education Act, has a different age than the child in the Penal Code for certain offenses. But the general one, the constitutional age for a child is now 18. So we've had an interpretation from the Constitutional Court that says upon reaching the age of 18, you are no longer a child. So it's basically 17 years, 365 or 4, depending on the DPA. But yeah, 3 or 4. So going this way, you're a child. Before there was some confusion because the wording in the Constitution said attained the age of 18. If you look at other statutes, they usually say a person below the age of 18. So at least you would know that the line is 1800. But then when it said attained, the question now, it depends on which school of thought you were at. Others said you had to run your whole 18th year. So 18 years, 6 months was still 18 years. Whilst there was another school of thought that said no, the line is 18. So the Concord finally resolved that issue and said the line is 18. So that's where we are at. In terms of the children and any consequences, the Diversion and the Child Code Act as a whole tries to make sure that they reform and also that they have no permanent records to their names. So even the cautions after a certain period of time as prescribed, they are actually deleted if it's a formal caution. After a certain period of time, if the child has not reoffended, the officer dealing with that matter is supposed to dispose of that. So the child will then not have a record like that going forward.
Yeah, and then just last thing on this point, I always see this one as sort of an interesting one, again, open to debate. If the offense happened before this child was 18, subsequently they turn 18 and beyond, they would still be treated as a child for the purposes of that particular offense.
Yes, they would. I think the idea there is that when you are committing the offense, your state of mind was that of a child.
Yeah.
So it would be then unfair to punish you then as an adult for something that you have when your mindset was still in a different phase, so to say. So but that is also, but it has created also. That's an interesting one, because it has created certain situations now in terms of sentencing. I think in terms of the trial, we don't have much issue, but in terms of sentencing, now the questions usually arise is that when normally maybe the child would have been taken to an approved school, but now they're too old for the approved school. And that would be the appropriate punishment or the appropriate sentence in this case. What do the courts do? So it's still, I think, one of those things where there is still ongoing, I think, discussions. And the law actually allows for several types of ways in which children can be dealt with even after they have passed that. So I think now just the infrastructure has to catch up with the law. So that we need there are certain what I would call them centers or facilities that are supposed to be transit centers and approved centers, which are supposed to be able to deal with some of these gray areas. Yeah, but I think as time goes on, we are catching up in terms of infrastructure.
Okay, and then maybe still whilst we're dealing with children, the child, one of the benefits most commonly spoken about with ADR is that it's supposed to be a quicker resolution method, right? So, and this, I think I want to hear from you from your practical experience of trials in the High Court, saying which involve children and these restorative, the ADR methods, right? What does the time frame look like? How long would it take if you took a child through the court system? How long compared to if you took the child through these ADR systems? Though, is it really that much faster? You know?
Yeah, I mean, on average now, I would say a trial for a child would take at least between 6 months to a year. Yeah, that is like the latest you can go. The law otherwise actually says you should not take more than 3 months. But then I think there are certain other processes that issues that come in. Maybe at times when the matter is supposed to come up, you have maybe illness and other issues, so that maybe that kind of problems. But before, I think I would say there was real serious issues around children and their delays, because the process before for children had so many aspects to it that required different parties to take part, and it ended up delaying the process. So, for example, when a child was at the point of, let's say, conviction, the social welfare office had to come in, and you needed a social welfare report before you proceed with that sentencing and whatever. So depending on the area that the child resides, they may not have quick access to a social welfare officer. That will already delay. And then if they are given, let's say, what I would call a sentence, so they are guided to go to the approved schools, which is like, let's say for a boy, it would be either Mazabuka or Katombora. So then if you have your child who is in Imbara, for example, or let's say they're in Sesheki, now the issue of transportation would have to come in. But before you even get to Katombora, that sentence had to be confirmed by High Court. Every sentence involving a child had to be confirmed by the High Court if they were going to go through that route. So then you find that now you have moved from waiting for a social welfare, let's say, officer, then the court itself where you were dealing with the matter. Then you have to now go and join the list of cases that are before the High Court for you to be confirmed and then now you have to wait for transportation to take you all the way to another province.
Yeah.
So at times, I can tell you this is unfortunate, but at times this process will sometimes you take 5 years.
Ah, okay.
We have had, and even now I've had cases of, I think the longest one that I've experienced is about 7 years. Where through this whole process of waiting for confirmation, waiting for this and that, the process ended up taking, even going, like you were saying, the child now becomes an adult.
Yeah, for 18, 5 years.
Through the system, yeah. So, but now when we use these ADR methods, diversion and whatever, you can deal with the case, for example, within a week or two. You have your mediation, you go through your restorative, the parties reconcile, and the child starts a program of reformation, which sometimes involves education, learning new skills, and it even becomes more or less like a positive comes out from the negative that actually happened.
Yeah.
So that is where we're at. In terms of speed, I think it's incomparable, actually. And I think also in terms of congesting the courts, now we no longer have to go through, the courts don't have to deal with now another set of confirmations that need to happen. And if you recall, I think prior to 2021, we didn't have provincial judges.
Yeah.
So you can imagine that many of the children were having to come to centers. They probably, if you are in Northern or Poorer, these cases would have to be confirmed all the way in the Copper Belts. If you are coming from Western, Southern, you had to find your way to Livingstone or Saga, and this added to the many days. So,
yeah. Okay. Now, I know one of the things we'll be going to next is plea bargaining, because I think at the moment it's a bit of a hot issue when you talk about certain things. But before there's a bit of a peculiar one. I've spoken to a few colleagues and traveled to a few countries. I think one which may stand out at this moment is Kenya.
okay.
And that's now with respect to restorative justice. Okay. I've been told that, look, traditionally a long time ago, before we brought in these court systems, we had, as African and African traditions, we had restorative justice. So sometimes they give me an example, even as for serious offenses like murder, they'll say, someone has killed the other. You sit down in the village as a family. This guy will agree, fine, this was wrong, I'm remorseful, and then it may sound funny. He says, oh fine, I'll give you 10 heads of cattle. I'll support, maybe if they kill the breadwinner, I'll support this person's family. Then, maybe a chief or the family will then sign off on that and say, look, this is restorative justice. We're happy with it. No point in having kill you because you killed our person. Do you, when do you see that? Is that something that can work in today's world? Not necessarily with murder. Maybe let's say for the slightly lesser, maybe serious assaults. Should we say, okay, fine, drop the court system. Let's sit down and restorative justice. This is what you've done. You're remorseful. Is there scope for, restorative justice in certain offenses, or do we just say, look, we're taking you through the court system?
Yeah. I think, like you said, this was before, I think maybe our structures changed here in Africa. Because I think the concepts that were introduced were an eye for an eye, and things like that, and words like punishment, and things like that. So we have really, and I think over time, generally as Africans living now, say here in Zambia, I would say like we're always coming up with newer ways to punish. I think we've become even the experts at punishments, because I think just when I was doing my master's, I learned that in Europe there's even diversion for adults.
Okay.
But I don't think here we even have that discussion. But I think I would agree, for certain offenses I think restorative justice can work. There are certain offenses which I think, in my experience, when people find themselves as complainants, I can tell you sometimes all they want is their property back, their money back, they want their car fixed, they just want their hospital bills paid. Because you have like issues like obtaining money by false pretenses. That offense is where you part away with some money and say, no, someone says I'm selling TVs and they never give you the TV. I think the person would be more interested in either having a TV or getting their marital leave. I think having that person go to jail for 6 months, 1 year, I think if we ask the complainant, it'll probably be low on their priorities there. So I think it could really work in those instances like that. And there's a lot of those cases around, especially around money, damage to goods, and even unfortunately assaults. It would work. It will definitely work. I think even for mid-range, if we move, like, for example, the reconciliation section was amended to also touch on maybe, because now it locks to misdemeanors.
Yeah.
So if maybe it was opened up to say, or maybe to create a list of offenses that could be reconciled and restorative justice used, I think it would work in certain, and then it would still carry that threat of the criminal punishment if you didn't want to reconcile or go through restorative justice. So I think it would actually help. I think there are certain offenses where it's very difficult to see how in the modern day you can have restoration. I would not say make out of the books, because manslaughter, for example, there are several ways that a manslaughter can happen. For example, we have the common causing death by dangerous driving.
Yes.
That's a form of manslaughter.
Yeah.
And it's usually taken that the accident, you had no malice when the person died because of your dangerous driving. And in that type of arrangement, in my experience, restorative justice has usually happened because most families of an accused in that situation will contribute to the funeral.
Yes.
Yeah, they'll push the insurance papers, if anything, and things like that. So you find that it's going on in that type of arrangement. So a death doesn't necessarily negate the whole restorative thing.
Yeah.
It's also maybe the circumstances around the death. I had a case some time back when I was starting out about it. It was a cattle herding. And he threw a stone as it was a community and they were herding their cattle together. One of them threw a stone and some things already happened. The stone hit the horn of the cow, bounced off the horn and hit one of the little kids. And the kid died.
Yeah.
So you see the circumstances, they had no
malice, no. Yeah.
So the death doesn't necessarily, I think, negate that, but then you have offenses particularly to do with you call it personal space, so your rights. And I think when we're dealing with particularly like rape and defilement, it would be a very tough discussion to have around restorative justice for cases along those lines.
Yeah, I think if I was the lawmaker there, that would probably be one of those where I would say, look, you're never going to have restorative justice there. Maybe you just need to go through the proper system and face the full punishment, I guess. Yeah. So that's that point now. I'd like you to shift a little more on plea bargains, because I know that's part of, we may say it's part of the ADR system in the criminal justice setup. And I know there's been a bit of word around it. How does it work? Does it favor this person? Should we be using it? Maybe we can take us through that bit of it, plea bargaining.
Plea bargaining, yeah. So yeah, plea bargaining is a catch word now. I find it, before I get into maybe where we are coming from and where we are at and where I hope we can go, I find it's a personal view. I find it unfortunate that there's been, and maybe the people who are commenting maybe don't understand, but I find it unfortunate that there's been some pushback against the whole process of plea bargaining. Maybe it's because of the cases that seem to be these days aligned to plea bargaining, more political in nature, and also they have to do with corruption. So everybody has their own view. Others will say, no, these are corrupt people, they deserve to be punished. So you have that, but maybe we'll get into that. But I think the concept of plea bargaining is that a person who is accused at that point of an offense, basically admits the offense. But before they admit into court, they tell the prosecutor, the complaint person, the institution complaining against them to say, look, I agree that I did this, but can you reduce the offense? And I'm agreeing to reduce the offense for this and these reasons. And the institution will agree most times based on whatever rationale they are using. And then the charge is changed. So when the charge is changed, because you have agreed, this is an agreed charge, when the charge goes back to court, the person also admits in the courtroom and they're subsequently convicted and sentenced. So they still go back to court. They're not completely in the alternative, but they still go back. But then what you have is speed. So you at cost. So you no longer have to call witnesses. Your whole trial from plea to conviction will take maybe even a week or less. So that's I think the basic concepts of plea bargaining. So in Zambia, what we have been doing over time, what the customer I found, and was that you have this discussion. Usually it was at high court level. So you have this discussion with defense counsel and prosecution counsel, and you say, oh, you charged my client with aggravated robbery. He says he did it, but it wasn't like this, so he's willing to agree to an offense of theft. And then the prosecution counsel will go back probably to the complainant and say, oh, look, we can say if this person wants to agree, we can say when you're having to come and testify in court, and the case will still go on and you'll be convicted. And I can tell you 9 times out of 10, the complainants will agree. Yeah. So violence, I think many people don't want to be witnesses. But but most of the times, because when you tell them this person is still getting a punishment, they say, okay, fine, let's go with it. And then you now change the charge or the information to the new one, present it to the judge. Then you have now a new plea on that information and facts are read, and there's a conviction. So this process was being anchored on provisions of the CPC that have to do with amending the information. There wasn't a provision in the CPC that was saying we are now doing plea bargaining pursuant to section what. So we'll just come up in the morning and say we're amending the information pursuant to this section. So as long as the judge gets the new information, they proceed on whatever information is given to them, and that would be the plea bargaining process. That's how it worked. So around 2010, if I'm not mistaken, there was an act that was passed, Plea and Negotiation Agreements Act. And this act now tries to create a legislative structure and process around plea bargaining. So it basically sets out the process, how you start, how you talk about this, what can be talked about, then how you present this to the courts. It gives you a format that you can use or a template, whichever. And then there are a lot of things that you can do there. You can suggest sentences to the court, and you can suggest any other alternative punishment to the court, and things like that. So that has been the law that has been there now. I must say that law, the uptake of that law is quite low. Plea bargaining is still going on at still a very high rate, especially with high court matters. But even now, if you did a survey, you find that act is not being used. It's not being used. I think the act is extremely technical in the way, this is my personal opinion, it's quite technical in the way it is framed. And then it's actually an act that kind of removes the speed from the process, because the way it envisages the process to go on, that process would actually take quite long. Because it has a lot of time gaps in between the submission of this and the submission of that, and you find that it might take even as long as a trial.
Basically taking us back
to the. But if you use the custom we've used in Zambia, because customs are also those.
Yeah.
Our custom we've used in Zambia, you find that the same thing you would have done with using the act. You do it in 2 days. With the act, it will take you 3 weeks.
Yeah.
So people still, I think, leaning back on the old customs, especially for the high court matters. Of course, I'm not saying the act it has been used in several cases. I've used it myself, also in several cases, especially where the parties and the defense want a document, like a template to say there was a plea bargain that was gone through and it ended this way.
Okay.
So the other issue with plea bargain is that it removes the way it is framed. I mean, this is also a school of thought, is that it specifically states advocates should do this. So an unrepresented person would not be covered by the provisions of the Plea Bargains Act.
Okay.
So then you have an issue, and as you know, the way we have a big country, you find that if an unrepresented person in Chifulamudi cannot then access the provisions of the Plea Bargain Act, so how do they get into plea bargain using that act when they don't have an advocate there? So those might be some issues that need ironing out. Going to maybe the other areas is the Anti-Corruption Commission Act. I think can't remember the section, should be 80. It's quite clear. It says you can go and engage in an out-of-court settlement and resolve your matter. That's how it says it. So it's not very detailed, but it gives a bit more flexibility.
And at least some form of general.
Yes. So it's a general framework. So you are anchoring it on this, and then you can proceed like this, and then you basically form however you want it to be, and you can conclude. But that's where now you have issues of people maybe thinking like it's a lesser punishment, or people are being favored, or things like that. But I think on this one, before I maybe touch on the last part, is that I think the arguments general, as you know, for ADR, issues of speed, you can quickly resolve matters. That in this country we have seen corruption cases, cases involving money laundering, and several other cases take decades, I think, to resolve. And then when you put what they call it, the cost per capita, like how much money would you have spent as a country on that case, and is it worth it? If you went through a plea bargaining, especially when you're dealing with corruption matters or economic and financial crimes, as they're called now, you will find that you even get a positive, because in some cases you have forfeiture of these profits, of these funds that were deemed to have been stolen. So you are finishing the case fast. You are getting the funds back, you see. And then I think it's the way these things are framed. You should be given a grade to say this person still gets a stint in jail, but maybe not as long as it would have been, and you close the case. But then now I think others would like to see like just a punishment, but it comes back round to the same thing. You punish someone for 5 years, they still have $15 million in the bank, they'll go. But why not try and resolve this for speed using a plea bargaining? The other types of ADR for criminal matters, I would say, involve regulatory organizations or institutions, ZRA, NAPSA, PACRA, where you find a call for amnesty.
Yes.
So what they're telling you is what would normally have been a crime: tax evasion, non-payment of contributions, and etc. You're given a time in which, with your voluntary, what did you use to call it? Your voluntary disclosure. Yes, that's the word. Voluntary disclosure. It basically cleans your slate, and you come to a form of agreement, I guess, with the agency, that you're dealing with. And what would have normally been a prosecutable offense is dealt with administrative.
Yeah.
And that's the end of the story. So I think, that's I think I think those are the types that I would say exist for plea bargaining around in Zambia in terms of the criminal justice system.
Okay. And then maybe just to close off our session, would you have any last final parting words around ADR and the criminal justice system? Anything just short for us?
Yeah, I think we need to embrace this. I think especially now, I should do so laugh as defense. Now with the defense, I think I've seen an appetite for sometimes for defense counsel to proceed with trials, which sometimes especially when I was at the prosecution in my experience, we were really wondering, is this something that we could just agree on and give a lesser offense and proceed? Sometimes I wonder what is the this just. Yes, clients give us instructions, but you are also there to give legal advice. I don't want to. I don't know how much detail I can give, but I saw a case in the newspaper. It involved some people who were charged with, I think, say obscene materials, and they were going on a trial.
Yeah.
And I was thinking to myself, is this a case where if they went to the prosecutor and said, can we get idle on disorderly conduct?
Yeah.
And then we can also in turn we give up our phones and then also do maybe community services.
Yeah.
And but then people are going, witnesses are being called, technology, the computers will have to be used in the courtroom to do what is a misdemeanor.
Yeah.
So you find like now I'm wondering if they're being, and I'm sure those are being defended. What is the rationale behind that type of trial? Especially that I'm sure the lawyer knows that these what they're suspected of is true.
Yeah.
There are certain cases where if you are going to trial, most like but when it is true, like that one is if the obscene materials in the phone, it was either there or it's not.
Yeah.
So you know at that point. So why are you going to trial? So I think we need to embrace it. I think we need also the powers that be, as they're discussing this, you can see there's appetite from last year, from the president, from the Chief Justice. I think now there needs to be a concerted effort to amend the Act.
Yeah.
We need to amend the Act to make it more friendly, to make it quicker for parties to use, to also maybe try and extend it to non-represented persons. Because sometimes, and also maybe to also put an obligation on a prosecutor to also inform a non-represented person to say you have this option. Because I think some of these persons they don't know that they have this option. They are willing to admit to a charge because they know the intent, but they're not aware that they could be able to reduce their charge simply because they are admitting. Yeah, so they will just be charged, and then before they know it, they didn't know that the offense that they're admitting to has a minimum of 10 years or 5 years. So I think we need to embrace it. We need to make those amendments to it, and I think we also need, generally as a society, to see the benefits. All developed countries, many developed countries use plea bargaining processes, especially when it comes to white collar crime. These trials, even in developed countries, it is better off to take a plea bargain, to get your conviction quickly, and even get a net positive out of the process. So I think ADR in the criminal justice system is, for me, it's a good thing, and I think we need to encourage it.
All right. Thanks for having come over. Very informative discussion. In the meantime, to our audience there, always remember, think all things ADR.